Our next speaker is Aoife Nolan. Aoife is Professor of International Human Rights Law at the School of Law, Nottingham University. She has published extensively in the area of ESC rights, children's rights, constitutional law. Aoife is founding coordinator of the Economic and Social Rights Academic Network UK and Ireland. She's acted as an expert advisor to a range of international bodies, Council of Europe, Council Commission of Human Rights, Special Rapporteur on Extreme Poverty and Human Rights. But for today's purposes, perhaps her expertise on budgets and human rights is most interesting. In over a 2-year period, she co-managed a project on budget analysis and the advancement of economic and social rights in Northern Ireland. And she has done a lot of work recently on austerity. Last Friday, Aoife was presenting to the 4 jurisdictions of these islands, the Human Rights Commissions, and we had a very good session with her, so I can tell you you're in for a treat. Okay, Aoife.
Okay, well, with the bar, sufficiently raised, there can only be disappointment. So, anyway, I'm delighted to be following. I'm just going to make this a bit lower because I'm a little bit smaller than Conor, who is blessed with greater height than I am. It's a pleasure to be here. Thank you very much for the invitation. I can't think of an event that's more timely, given the current political, economic and social context, which Colm so effectively outlined earlier on. What I'm going to talk to you today now is, in this session, we've already heard about the Irish constitutional position with regards to economic, social and cultural rights. And what I want to focus on in my presentation is, first of all, essentially 2 key questions. First of all, what is the purpose of putting or having economic and social rights in a constitution? When it comes down to brass tacks, what does that actually mean? What is the value added, right? And second of all, in answering that question, I'm also going to look at how other European constitutional systems have dealt with threats to constitutional, economic and social rights in the context of economic crisis. And I want us to think about what lessons there may or may not be for Ireland, right? So let's start relatively. So let's begin with the idea of the purpose of putting economic and social rights in a constitution. Now, what I'd like to say is when you say economic and social rights, normally there is the gentle sound of hysteria. You hear people mutter courts, lawyers, litigation, floodgates, the state being brought to its knees by defending case after case in which, someone wants some highly costly drug of questionable effectiveness, which the state is then forced to provide, resulting in thousands of people being denied primary healthcare services, right? That is the kind of nightmare scenario that is frequently presented. That if you have economic and social rights in a constitution, sure, elected representatives, decent, hard-working people might as well give it up, Well, I would make a joke about allowances at this point, but actually, I'm with an Irish audience, we all know what I mean. They go home, sit back, enjoy their allowances, and, leave it all to the courts, who are only too keen to take over control of every single possible function of government. But that isn't what it means. Economic and social rights, the aim of them is for them to serve in a constitution as a mandate for all branches of government. If we look at our constitution, and we look at the way that rights are referred to, we see references to the state and to organs of state that are required to give effect to constitutional rights, including education, which Conor just spoke about. That's the legislature, the executive, and the judiciary, right? It is for all 3 rights, even though we tend to talk about courts when we're dealing with them, actually are for all 3 branches. Furthermore, and this is to echo what both Ignacio and Colm highlighted earlier, constitutional rights serve as a framework, the parameter for state action or inaction in all areas of law and policy making, right? It is a commitment of societal values that we have entrenched in law. And that is reflected in the language of the Constitution. It is reflected in the way in which constitutional law is implemented. Crucially, what it means is that human rights in a constitution are not just about, say the ECHR Act 2003, which is our big domestic legislation on human rights. It's not just about when we look at, education issues for children with disabilities. It's where we're looking at any kind of decision with human rights implications, of which there are many. The classic example being the one that was highlighted earlier, that when we're talking about decisions about economic policy making, resource allocation. Now, if you were to go into a meeting with government and say, well, actually, there are human rights standards that, are in the Constitution, for instance, education, these need to be taken into account when you're, deciding to, pour money into, or when you're deciding about tax levels, for instance, because if you have to give effect to the right to education, you need a certain amount of income. And you'll see the relevant minister going, goodness no, I think you'll find that that's for justice, or perhaps for DFA if it is an international aspect, but that's not the way it's meant to work. Rights are meant to be a central part of all exercise of governmental functions, not just by the courts. Elected branches of government, they have the primary responsibility for protecting and implementing economic and social rights. Why? Practical, right? We look again at our constitutional framework. It's like most others. When we look at where the power of the enforcement power, policy making, but control of budgets, resource allocation, it's with the elected branches, right? So practically, it makes sense for us to look to them to give effect to decisions about social and economic policy that affect constitutional rights. There's also the issue of legitimacy that Conor talked about. The fact is that the elected branches of government are accountable. They're not a little judicial elite that can kind of, sit in the court and ignore what goes on around them because they know that they have a guarantee of tenure. So we have practical and legitimate reasons for, when we talk about economic and social rights, focusing on the elected branches, not the courts. Another thing that's important about why would we have constitutional economic and social rights in addition to the right to education, is the fact that our domestic experience shows that the directive principles that were put in Article 45, protection of the vulnerable, the orphan, the widow, beautiful sentiments, sincerely meant in 1937, absolutely no bloody use at all to the average right holder. They have been constitutionally minimalised, right? And do you know why that is? Because they have been deemed unenforceable by the courts. So basically, on one level, you can say, fantastic, isn't it lovely to have these aspirations in there? On the other hand, what is the point of having a lovely aspiration that in fact has no impact whatsoever on governmental decision making? So, moving swiftly on, Conor's already talked about South Africa. I just want to highlight that where we have constitutionalisation of economic and social rights in different countries, far from what is frequently claimed, it hasn't resulted in courts leaping to grasp the role of primary law policy makers with regards to economic and social policies. We don't want courts doing it, and by God, they don't want to be doing it, right? This is not something courts embrace. And it's also, this is true even where you have very extensive economic and social rights, constitutionalisation and adjudication, right? So even in South Africa, Latin America, at the US state level, we don't see courts leaping to take on a role. It is a role that is generally forced upon them. And we also see that where courts are dealing with constitutional, economic and social rights in the context of resource scarcity. For instance, in a time of economic crisis and austerity. The other thing we need to bear in mind is that I'm not claiming that if judges deal with economic and social rights, that isn't going to impact on social and economic policy or distributive justice issues. The fact is, part of the reason for bringing that litigation is because we want, or for the courts to enforce that right, is because we want to see an impact on policies that, have implications for the rights of the most vulnerable. The other thing we need to remember, and in Ireland there's a huge tendency to go, well, distributive justice, that's not for the courts. Well, you know what? The courts deal with it all the time. Tax law. No one complains about the courts dealing with tax law. Guess what? Huge implications for, the budgets that are available to the state. You strike down a particular provision, that obviously has implications for the amount of money that the state can gather to put towards, budgetary allocations. Another example, the Article 26 in the Health Amendment Bill, this is the case that talked about kind of imposing retrospective inpatient charges for people in residential homes, largely older persons, and it was struck out. Huge implications for the financial plans of government with regards to care and other aspects of policy, of social and economic policy making. But guess what? It came down to the right to property, so you didn't hear a whisper of complaint. So we're all about distributive justice implications. It's grand if it's property. Heaven forbid that we should suddenly start talking about health or education or any of those, other rights. What do? Courts have a reactive role. They only enter the picture if there's a problem. In an ideal world, courts wouldn't have a sniff of the action on economic and social rights. The function of courts with regards to economic and social rights is to hold the elected branches of government to account for their economic and social rights obligations under the Constitution. This is exactly what we expect the courts to do for civil and political rights, and which they do in Ireland very effectively, right? There's nothing new here. The other thing that they have to do is to ensure that economic and social rights are vindicated, this language, heavy language, vindicated, given effect to that we see in the Constitution, and that right holders are given effective remedies where there are violations. Again, they're already doing it in private law, civil and political rights, constitutional case law. This is not a new area, right? So it's not exactly as if we're looking for, it would be a huge shift in judicial practice or the judicial role. I now want to talk a little bit, that's kind of general observations about economic and social rights. I now want to talk specifically about the issue of austerity, right? Because guess what? We're not the first place to have an economic crisis. I know it's a huge one, it's global, it's much broader than some of, for instance, the Argentina crisis a few years ago did not take place in the context of a global economic meltdown. But there are lessons that we can take. So, for instance, let's take a Hungarian example. And this will sound familiar because this was a measure that involved cuts to social benefits that was specifically required because they needed structural adjustment in light of, that was required by the IMF. Sound in any way familiar? And it was declared unconstitutionally disproportionate. And why? The Hungarian constitutional, it was to do, the measure failed to protect vulnerable groups. There was an issue of legitimate expectation that you can't be making changes to benefits and the expectation of what the state will cover overnight without sufficient reason. In this case, there had been no run-in time. There had been no proper education about the measure, and it was just literally here today, gone tomorrow. And furthermore, they said that where the insurance element, right, so where you're contributing, where the state is playing a role with regards to covering people in the social security system, the constitutionality of the reduction or termination of benefits, hideous legal phrase, should be evaluated according to the criterion of protection of property. That says when you're dealing with social security and you're dealing with social insurance, there are property elements here. So we're not just looking at economic and social rights, we're seeing a role for property and protection of property because that benefit, you have a property right with regards to that benefit. We see similar stuff under the European Convention of Human Rights. Latvia. So this is a 2009 case, so much more recent. You've got reductions in pensions passed in an effort to reduce the state's budget deficit. Again, I think very familiar sounding. And the court found the law to be unconstitutional and a violation of the right to a pension, so the right to social security, effectively, because the state hadn't considered less restrictive alternatives. So for anyone who's a lawyer who deals with the ECHR, the proportionality test, the idea that you need to see if there's a less restrictive way of achieving the legitimate aim. The court, again, we see there hadn't been an adequate transition period before the new scheme took effect. And also, in this case, the court noted that minimum essential levels have to be guaranteed irrespective of resources, and vulnerable groups such as pensioners have to be particularly protected, right? So this was about pensions, that's why it's focused on pensioners, but you would see older persons, people with disabilities, all the people that are also vulnerable in our society. You also saw a very interesting thing where the court refused to recognise loan conditions as a valid argument in support of the law's reduction of pensions. In other words, obligations to the IMF did not trump constitutional protections. Very important point, and I'll return to it later. Germany, right? We hear a lot about Germany in the context of the economic crisis, but they themselves in the last few years have seen huge changes to their social welfare system generally. And this was a massive case in which the court, you can see all these joined complaints, where the court was asked to scrutinise the process by which the legislature set levels of welfare and unemployment system as part of an overall change to social welfare. So this wasn't ad hoc. It had gone on for years. There had been a huge amount of work over it. The case is an absolute... Be grateful that you will see the case summarised in 2 slides. I feel that I've lost years of my life reading it. It's 73 pages. It's about social security law. And German social security law leaves ours to be... Anyway, without indulging in racist stereotypes, imagine German social security law, right? Very detailed, very well thought through. Anyway, what they said, and this is crucial, is that under the German constitutional system, the fundamental right to the guarantee of a subsistence minimum exists, and that is that guarantee of a subsistence minimum, right, so a survival minimum, effectively, comes from the right to dignity and the principle of the social welfare state under the German constitution, right? And this is the idea. Essentially, it says that under the German constitution, each person who needs assistance is guaranteed the material prerequisites which are indispensable to his or her physical existence, right, so survival, and for a minimum of participation in social, cultural and political life. So we're not just talking about avoiding people not eating in dustbins or children fainting from hunger from schools. We're talking about children being able and other members of society being able to participate properly in society, decision-making, other activities. Very important. The court did not turn around and say, well, actually, this is what the level of benefits has to be. You have to pay such and such an amount to such and such a group every month or whatever. What they turned around and they said was that the court's role is to ascertain whether the benefits are evidently insufficient and to examine the bases, right, so the grounds for and the assessment method of the benefits to ascertain whether they do justice to the objective or the fundamental right. So the key thing is they're looking at the basis of the legislature's decision and the reasons for its decision and what it took into account in making its decision, right? So it's looking for rational, reasonable decision making. The court looked very carefully as to whether the legislature had chosen a fundamentally suitable method of calculation for assessing the subsistence minimum, right? So was their approach reasonable, suitable? Had the legislature correctly and completely ascertained the necessary facts, or was it going on kind of half the picture or a skewed picture? Had it also kept within the boundaries of what was acceptable within the chosen method and its structural principles in all stages of calculation and plausible figures? In other words, when applying the system that it chose, did it apply it correctly, right? So it was about the process applied and whether that process was, the model applied and whether that model was applied correctly. And what a very important part of this is that resource decision making is often confusing. If you challenge a government decision, they'll say you can have no idea of the other demands upon our time and on our resources. And what you saw here was the court saying that the legislature had to disclose the methods and stages of calculation employed in the legislative procedure. They weren't going to turn around and say, oh, those are wrong or those are crazy, but they wanted to know what had been decided when and why. So it's about providing justifications for good quality reasoned decision making. We also have a more recent case, very important one, and this is the Asylum Seeker Benefits Act. It in fact applies to all non-citizens. It's called asylum seekers, but applies to legal migrants as well within the context, living in Germany. And this was interesting because what happened was that there was a challenge to the levels of social security. They said that they weren't adequate, and indeed they weren't. The court in fact found they were evidently insufficient. So they were too insufficient because they hadn't been changed since 1993. This is 2012 decision, right? So in 19 years, they hadn't been changed despite considerable price increases in Germany. They hadn't been comprehensively calculated, and you hadn't seen a realistic needs-oriented calculation, right? So again, they're focusing on the process, and they say that the process did not result in sufficient levels being established for the benefits in question. So very, very important. So where might constitutional and economic social rights get us, right? First of all, and it would depend on the model we take, but these are kind of common themes that we see in the case law. They would require the state to consider the position of the most vulnerable in its law and policy making on regard to economic and social issues, and to ensure that the protection of those groups be prioritised. Think about the current context. Think about the current talk as we approach the budget. Think about the Disability March last night and Age Action's campaign around older persons' rights. They establish economic and social rights as a factor to be taken into account in negotiating bailout terms, for instance. And in domestic economic decision-making, they say this is something that has to be taken into account. It has to be balanced against all the other issues. When we negotiate with the IMF or the EU, these are values that we have to pay attention to too. They enable judicial scrutiny of the bases and assessment methods for levels of economic and social rights related services to ensure constitutional compliance. And what's notable is that in all those cases, there is a minimum established beyond that guaranteed in terms of Article 3 of the ECHR Act 2003, which hasn't, I think, been dealt with in any detail in Ireland, but in the UK, a very low level of survival needs is covered by Article 3. And I don't want to get too involved in the legal ins and out. There's also a possibility that the right to life and right to bodily integrity under our constitution can be interpreted to give effect to subsistence needs. This was suggested in 1996 by the Constitutional Review Group. We haven't seen it being borne out in the courts. And what's notable is that all of the approaches, all of the countries I've looked at here would bring us beyond that kind of basic survival, able to get out of bed in the morning standard. So once more with feeling, what are they for? Constitutional, economic and social rights make our priorities clear, make clear the priorities. The governmental decision-making on policy law and resource allocation should reflect in good times and bad. Rights aren't just for the good times. And frankly, we'd probably be in a much better position if we'd put more rights in during the good times, given what we're faced with in the bad. I want to leave us with two questions, and they're two questions that echo what had been said already, but they're actually questions for us as a society, especially given the recent referendum. We're prepared to constitutionalise certain goals with regards to resource-related decision-making. Okay, so we've got this balanced budget requirement that Ignacio talked about. But we aren't prepared to constitutionalise rights protections by which states can be held responsible for ensuring goals related to fundamental human rights. Why is that? Why is it that during the debates about the Fiscal Compact Treaty, that this wasn't a key issue, that someone turned around and said, this is clearly going to make provision for public spending cuts that are going to impact on the most vulnerable, and it just wasn't a key focus of politicians, of voters, whatever, or the media. The other thing I want us to ask is, why are we prepared to constitutionally copper fast on austerity, which is a probable effect of our ratification of our passing of the proposed amendment on the European Fiscal Compact? But we're not prepared to constitutionally entrench rights that would mitigate to serve the limit of the impact of austerity policies on the most vulnerable. Why is it that economic and social rights are off the table for the Constitutional Convention? Why were they off the table for the Children's Amendment? Okay, so we have to ask why we let that happen. Sorry, thank you.